Graham is here by the looks of it.
Hello and welcome from the Property Marketing Strategists. I'm Sarah Canning.
And I'm Deenie Lee.
We feel very privileged to be bringing you this timely webinar on the Renters' Rights Bill in partnership with Housing Hand. Thank you all for joining us this Friday lunchtime. We've got a fantastic array of panellists who will introduce themselves today. So let's start with Ryan. Would you like to introduce yourself, Ryan?
Hi everyone, my name is Ryan Heaven. I'm a solicitor at Woodstock Legal Services, and I've generally been giving my 2 cents about the whole renters' rights process for a good number of years now. So that's why I'm here.
Perfect. Dan?
My name's Daniel Baker. So I work for Joint Living. We're a student-based landlord and letting agent. So we do HMOs mainly in Bath, Bristol, and Brighton. So we're sort of uniquely positioned as landlords and agents, sort of seeing both sides of it with a bill coming in. So yeah, that's me.
And James?
Hi, I'm James Maguire from Housing Hand, and I've been in the property industry for around 15 years, so know all about various parts of it and the student sector for the last few years. And obviously at Housing Hand we help students and working professionals who need a guarantor when accessing rental property in the UK. So looking forward to the panel today.
Fantastic. Thank you, James. And we do hope to have Graham Hayward here, but we had a couple of technical issues and I can't see him. But Graham, are you there?
Yes, I am.
Oh, fantastic. You can introduce yourself then.
Thanks, Sarah. Yes, obviously Graham Hayward. I'm Managing Director of Housing Hand. Probably most relevant for this session, though, is I've been around regulatory change for probably the last 15 years. So this is a very exciting time, and I guess the rental sector.
That's great. Thank you all for our panelists, and thank you all for everyone who is joining us and still joining us today. Thank you very much for being here. But I guess the question is, why are we here today? I'm sure that you've all already digested a lot of information about the Renters' Rights Bill, but until it's passed in Parliament, what can we possibly say that hasn't really been said before? We think actually probably quite a lot, which is why we've got this brilliant panel here today. What you won't be hearing from them, we hope, is we don't know for certain, because that's a given. We obviously don't know for certain, but there's plenty we've got good evidence to believe will be passed, and therefore we'll be filling this webinar with lots of lively debate around that and key practical takeaways. It's likely we're not going to have that long to wait until we get the decision heard. However, there's many considerations that will need to be swiftly moved through. So with our panel's expertise, let's ensure you're in a good place to make those significant changes within your businesses. I guess a good starting point, Ryan, if I can possibly come to you, is just kind of when the bill is likely to be passed and enacted into law.
Yeah, a good point is to know when we need to, or what the date's going to be in our diaries. I had thought that we would get the third reading of the bill in Parliament before Christmas, but no time's been allotted for it, so that's not going to happen, basically. What that means is we're going to have to look to the new year. Parliament's going to pass this bill at a third reading. There might be some amendments coming in, but I don't think they're going to drastically rehaul anything. You might remember the palaver of the Renters Reform Bill, where there were lots of amendments being proposed, but that's because the government was undergoing a bit of a backbench rebellion, which simply isn't happening for Labour on this. So if there's going to be any changes at all, they're going to be quite minor. They're basically going to be only the ones that government support. They've rejected all other amendments so far. So what that means is basically the bill as it stands is probably pretty much complete with just a few minor tweaks. I think we're going to get it passing through Parliament and House of Lords by springtime. Now, spring is obviously a 3-month period, so that's a little bit vague, but that's probably the best I can do. With a view to it coming into force in the summer. Now, summer is what Matthew Pennycook, the housing minister, said he wants to aim towards. Summer, again, a 3-month period, June through August. I think what that means is we'll probably get about 3 months notice between when the bill passes the House of Lords and becomes the Renters' Rights Act and actually come into force at some point in the summer. I don't think they're going to kick the can down the road with this. I think they're determined to bring it in some shape or form, even if that means we get less notice than might be desirable.
Okay, that's great. And I think 3 months isn't a lot of time really to kind of prepare, hence why I think it's good to have this discussion today. So what will happen on that day when it first comes into law? What is there going to be any significant changes? What are the main changes on those tenancies?
Well, one would be, for example, if you have a fixed term contract. So there's this kind of there's this legal maxim which is that statute trumps contract. So if you have a fixed term contract on the day the law comes into force, the fixed term is simply going to immediately end. You will be on a periodic contract. It will be periodic only from the point where where the law comes into force. Now, you don't actually have to necessarily do anything. There's nothing in the rules which says you need to notify your tenants that, hey, we signed up to a fixed term contract, but that doesn't exist anymore. That might be something that's introduced by amendment, and it's something that they did in Wales when they were revamping their legal system. They made sure landlords had to give tenants information about what the changes were, how their rights were affected as part of the process. But that doesn't seem to be in the mix so far. So if we're looking for things that we need to do on D-Day, not necessarily anything. We do have one eye on the student sector, though. Bearing in mind this is going to be a webinar mostly attended by people who practice in the student sector of lettings. The implementation date will be the point at which you need to be serving notice on tenants that you might want to rely on the student HMO possession ground, which we may well be talking about a little bit later on. But the clock starts when implementation happens, and you have a 28-day period to tell your tenants for the upcoming term, assuming it happens before September, that you might be giving them a Section 8 notice at some point in their contract, so as to bring it to an end in the summer of the next year, which will be 2026. And a pre-notice is a prerequisite for that. You can't give the notice to your students unless you've given a notice that you're going to serve them with a notice. So you've got a pre-notice and then you've got a notice, just to create a word salad there.
Thank you, Ryan. I was going to say that sounds really simple, but it doesn't, if I'm honest. So I'm looking forward to this discussion over the next 50 minutes. And Graham, you're obviously talking to operators, landlords, accommodation providers, universities all day, every day. Would you say you're getting a feeling that the sector is prepared for what's going to happen and are starting to make those changes, or are they very much waiting for the stamp to be made on the bill?
Yeah, I guess probably the simple answer to that is no, I don't think that they're ready. And that's and just adding to I think Ryan's great comments there. One thing I didn't realise, Sarah, was that since the committee stage happened in, I think, early November, there's been something like about 16 different meetings that have happened, which have all proposed amendments. Right, so this is a bit of a moving feast still. So I can quite understand why the market generally, is saying, I don't know quite where it is, because it's a bit of a moving sands as we go through. And part of the risk of this is obviously, you start to prepare, and then some of that basis of your preparation starts to go somewhere else. One great example was something that came through, I think, on the 13th of December from the committee. So, 12th, yesterday, was that I think we'd all been working on the assumption that you could get you could get with the tenant's approval, you could get an upfront payment. In other words, you can't contract for it, but you could accept that if that's what the tenant wanted to do. Right. This latest amendment actually says any payments other than monthly rental payment is illegal. Right. So you can't get upfront payments, but that's mostly for HMOs rather than PBSA. So these amendments are still going. So to answer your question, no, I don't think people are prepared. I think they're trying to get prepared, and it's great that they do, because you need to be compliant rather than illegal.
And Dan, you're right in the heart of this. You're a landlord and an agent. I know through previous conversations that we had that you are preparing your team and your business for it. what do you believe that you'll be required to do kind of ahead of implementation, or are you waiting for that final stamp to be made?
I think there's lots we can sort of prepare and with the sort of best guess of what everything's going to be based on what's been discussed so far. So I think things we're sort of doing are looking into amending our contracts, so talking to solicitors and getting our contracts in line, ready for when this happens. At the moment, we're still signing tenants up for next summer based on our current contracts and our existing contracts, but we're going to get something in place where we've got a new contract that sort of encompasses all the changes. I think all the tenants are going to be made aware of it a lot by student unions as well, so it's not like they're going to sort of go into it not knowing. I used to work for a student union in Sussex, and they're going to make students very aware of the changes, so I think it's something we need to be aware that they're going to be aware, sort of thing. So there'll be a lot of questions. In terms of the office, I think we're sort of thinking there's going to be a lot of admin. So the admin increase is going to be a lot of people moving in and out sort of all through the year, rather than the sort of clean summer period we have now. There's going to be a constant flux of people in and out, or potentially moving out a couple of months after they've moved in because they don't like the house. So looking at what we can do as landlords to sort of mitigate those risks and make sure that we've got something in place to refill rooms if people move out, and sort of making sure that we're aware of the risks that are going to be there. So yeah, at the moment it's a lot of sort of guessing, but you can have a pretty educated guess based on what's out there at the moment.
Thank you, Dan. And James, you've got your hand up.
Yeah, so just to add, been having a lot of conversations with our international marketplace partners. In fact, came off one this morning with one, and they're really keen to understand renters' rights as well, because they want to make sure that the students that they're onboarding and supporting the student market, that they are aware of of their rights, so to speak. So it's really refreshing that our international colleagues are looking to understand the regulations more as they come in, because I think it's important that and great that the student unions as well are involving themselves, because I think it's really important that everybody's aware, landlords, students, letting agents, the whole market as a whole, and it's great. We're also with one of our embassy partners yesterday, and they are really keen for their citizens that are coming to the UK to understand what's coming down the road.
It's a really good point there, James, I think, and I don't know what I've seen about this, but what have you seen around kind of providers, agents, the sector generally communicating to what is the customer around these changes, how they're going to affect them, and what is the things that they need to prepare for, really?
Yeah, I think at the moment, following on what Graham, Daniel, and Brian have said, I think because there's so much unknown yet, even though most of the bill will stay when it becomes an act, will stay as it is. People are unsure what to communicate, and I think that's where the confusion is. And so I think a lot of people are sort of holding fire, trying to gather as much information as possible. I think we're all attending lots of different webinars to try and understand the renters' rights bill more, and how it will affect the industry. And that's not just the student sector, but also the working professional sector as well, which we work in. I know most of the people on this call are very student centric, but it's going to affect every tenant, and of course directly it's going to affect HMO, BTR and co-living, because of the types of tenancy agreements they have. At the moment, PBSA will be exempt as we see it, but I think that they will be indirectly affected, because and that's why there's PBSA partners on the call today, because they need to know what's coming as well, because they they're going to be competing against those where the change is more stringent, so to speak, and so they're going to have conversations with their customers in terms of what their preferences are. So it'll be very interesting for sure.
I think on that subject of PBSA, James, Jane Crouch has asked a question in the Q&A. So to anyone else, please use the Q&A function. But Jane asks about PBSA tenancies, and will that affect council tax exemptions and licensing regime? Ryan, I'm going to direct this one to you. Kind of, I guess we need to clarify first of all I guess, what is a PBSA in what will be classed as a PBSA versus not a PBSA? And, if we're, I guess, where are we on the certainty scale of PBSA being exempt or not exempt from the bill?
Yeah, thanks, Sarah. You're right. It's probably worth talking a little bit about PBSA, because the idea is that the student sector is basically going to be split into two: purpose-built student accommodation providers that sign up to a code of conduct are going to be basically non-assured tenancies. We call them common law tenancies now. That means you have things like, for example, the Tenant Fees Act doesn't apply to them. The requirement to register deposits doesn't apply to them. As for those two specific questions about council tax and licensing, those are not assured tenancy specific requirements. So even if the PBSA tenancy was not an assured tenancy, you could still get, for example, council tax exemptions, and you may still be required to comply with licensing conditions. So I think that answers that specific question. The idea is that this is going to be made exempt by expanding an existing exemption to Housing Act tenancies already. So in Housing Act 1988, there's a list of tenancies that cannot be assured tenancies. And one of those is basically university providers of accommodation, so halls of residence. The idea is that that will be amended so as to include PBSA providers who are signed up to a code of conduct. Those codes of conduct are, there's the Accreditation Network UK, and there's also Unipol. And my understanding is that once you are a member of those schemes, they would occasionally check the quality of your housing stock to make sure you're still up to scratch. But you don't necessarily. I think you can still get the coverage of being a member even when you're building accommodation. So you don't necessarily need to have the building built in order to be a member of the scheme. It is my understanding. Bearing in mind there's two schemes and they might operate slightly differently, it's probably worth deferring complete clarity and judgment on that, and maybe just speaking to the two schemes themselves. But yeah, you have these two different sectors. You have the PBSA, which have fewer rules on them, and then you have essentially everybody else who will have to govern it through the assured tenancy model. And that means, you have Section 8 notices on ground 4A, that's the student HMO ground. You have your purely periodic contracts. So given that the PBSA are going to be under fewer legislative restrictions, really the only issue they'll need to bear in mind is what the market wants, whether or not students will prefer tenancies which are governed by the Renters' Rights Act. And I don't think actually PBSA even have a choice about it. If I'm thinking out loud here just for a second, if they fall within the exemptions set out in Housing Act 1988, they cannot be assured tenancies. There's not discretion. It's not they might not be, or if a landlord chooses, they might or might not be. It's simply saying it can't be an assured tenancy. So let's say if the market is saying that tenants want, let's say, a 5-week deposit cap or something like that, or they want purely periodic contracts, and actually the PBSA providers are suffering as a result of that, they might need to change their tenancies to emulate an assured tenancy. Even if they're not required to do so.
Right, thank you, Ryan. As James said, we can see that there's people from various different organisations and backgrounds on the call, so it's really useful to cover all those bases. I just want to ask the next question to the panel as a whole. Is let's just put our student hats on now, really. And James, you've talked a little bit, I guess, about organisations that have been asking questions, but are we getting a sense that students are aware of anything and kind of how they might be feeling, right now? And I guess, Dan, you're kind of dealing with students, coming into your office. Is there any indication from them that something's going to change?
No, I mean, so far we've not had a question about it. We've got tenants signing contracts at the moment for next summer, and I haven't asked the other team, but they would have come to me, I'm sure, to ask questions. But no discussion, no questions, nothing. So I think they're generally, as a population, students are quite unaware that it's going on. I think it's something that once it's sort of brought, probably a new year thing, it will come out more. I think the unions will get involved more. Universities will probably put some publications out about it. But at the moment, we're not seeing a lot, and we've sort of already let a fair portion of our portfolio not have any questions, so it doesn't seem to be on the topic much.
Yeah, I think that's a really good point. And, I think we made it before that even if you're not, you don't think you're going to be impacted directly, so maybe you're not an HMO, if you work in and around students, you're probably going to be asked lots of questions about this. Everybody that works in this sector, whether you're a university, PBSA, even if, your contracts aren't changing, I think, we all need to be responsible for, helping and, answering those students. Deanie, do you want to go to the Q&A now? We've got a few coming through.
We've got quite a few coming through, so thank you everyone for that. Do keep them coming. I'm going to go to Sammy's question. Under the new legislation, if a student chooses to leave their agreement within the first 2 months of a 12-month agreement, will they only be liable to pay for 2 months of rent, meaning I will no longer be able to pursue them or their guarantor for the remaining 10 months of rent?
Great question.
It is a good question.
I guess so. As Housing Hand, we've been sort of tracking this, I guess, very closely, because we're very conscious that what we understand that means is that, yes, in fact, someone that gives 2 months notice, at the end of those 2 months they can walk away, and the guarantor can as well. In fact, something that we've got probably on the back burner here, Sarah and Deanie, in terms of an extension to our guarantor product, is to try and help that period of void. I think void is one of the biggest challenge areas for HMOs or BTRs, where trying to find replacement tenants during that period is challenging. I think, building on the point that James made earlier, is that I think, and it might not be in the first 6 months of this, because the market's going to take, and particularly students are going to take time to wake up to it, is that you're going to find that people will start to trade around, if you like, in terms of accommodation and terms. For example, if someone legitimately gives notice and leaves, they get a void. What's that landlord going to do? They're probably going to renegotiate rent or drop the rent, which actually has an effect on the rest of the market. So there's a bit of a domino effect that I think is gradually going to come in around this. But watch this space in terms of what Housing Hand are going to do regarding helping some of those accommodation providers with void periods.
Sounds intriguing, and I'm sure very, very, something that will be very much needed and reassuring for the sector, that there is going to be a solution there for, what is probably the number one burning question on everybody's lips, really. We've got another question from Karen about, can the university give common law tenancy as the landlord on a private HMO and still be a PBSA? I'll leave that with Ryan, because I'm not sure I understand the question.
Thanks for that one. I think there might not be a need to think of it that way. So if the purpose of being a PBSA in this context is to escape the Renters' Rights Bill, a university is already exempt because they already fall within one of those exemptions that's currently in the Housing Act. So in that sense, you perhaps don't need to worry about being a PBSA, because it doesn't give you anything you don't already have. You can, as a university provider of accommodation, give non-assured tenancies. I think a lot of universities are signed up to be members of the schemes anyway, because it looks pretty good, to be honest, to be a member of these accreditation schemes. But I don't think it gives you anything.
Just a quick question, I guess, on the accreditation scheme is who should be signing up to these, and how quickly is it that they're going to be able to be signed up? Like, is that going to be a quick thing, or is that something that people need to plan for if they need to sign up to those accreditation schemes?
Well, I don't want to cop out, but I truly don't know the answer to how long it might take to do it. In terms of who can sign up to it, I mean, I could see one of the questions is can a single HMO landlord use a non-assured tenancy? And basically the answer to that is no. You can only use a non-assured tenancy if your tenancy falls within one of the exceptions in the Housing Act. So unless you are, as a single landlord, also a purpose-built student accommodation provider, which to be honest, I don't think you are, then I don't think you'll be able to get the accreditation, and therefore I don't think you'll be able to get outside of the Housing Act that way. So in terms of who should sign up, I think a lot of people in the sector who are operating PBSA models are signed up to this kind of stuff already, because again, it looks good. If you're not, you need to be, unless of course you want to deal with the fact that you will have to comply with the Renters' Rights Act, because this is your only ticket out of that legislation, is to get signed up.
Yeah, and just building on that, Deenie, I think part of the challenge here is the different zoning authorities, and how they certify properties in different locations. That can be very different from what I understand. So you might get approval in one area but not in another, and particularly if you're moving from an HMO BTR type environment into a PBSA, or you're attempting to make that move. Councils, are probably not going to vote very quickly for that, because they lose council tax in that process. So, I think that boundary is going to be quite hard to get across.
Thank you. And I think at the moment we're talking about, I guess, quite the immediate future, really. And one of the things that's been talked about quite a lot is the general impact on the housing market. Will these rules deter landlords maybe to keep hold of their HMOs? Will there be a sudden kind of, I guess, mass departure, creating even less supply for students? Dan, are you seeing any of that in the markets that you operate in?
Yeah, I mean, so our sort of business model is we are constantly buying new houses, and we're seeing a lot more HMOs, like ready licensed HMOs, coming up on the market to buy. A lot of people reaching out to us as well, seeing if we want to buy their HMOs. So there's already a bit of a wave of people leaving. I think it may just be people with maybe 1 or 2 HMOs, maybe near to retirement, that will be quitting. But the bigger companies like us, we're still buying houses. We're still pushing forward. It's not going to deter us, or a lot of operators like us. I think it's just about being clever with the way you manage it, and sort of offering things like single lets. So we do single lets. All of our rooms are single lets, so it makes us a lot more agile and able to sort of pivot. And I think a lot more landlords will either move to that sort of system, or they will exit the sector. But at the moment, there just seems to be a bit of a trickle of people leaving. But I mean, you read articles everywhere. There's some people saying there's going to be a mass exodus, some people saying there's not. So it's sort of hard to say at this point.
James.
Yeah, just to add to what Daniel's saying, I think we always get this sort of, I'll use the word scaremongering, when the stamp duty changed for landlords that had additional properties. A decade ago, there was quite a lot of scaremongering around. Loads of landlords would exit, they would stop using it. Other sort of legislation came in, the Tenant Fee Act, when that came in, and actually you're always going to see people exit the market. That's just a general sort of churn, and yes, you might see a little spike, but while there is an opportunity for people to supplement their income, most landlords are accidental landlords. They subsidize, they use rent for their pension, for their income. They're not big multinational sort of businesses. Some are, but in general they're not. So as long as there's still the yields and the returns that they can get, they'll stay in the market. And in fact, the student market offers, as we will talk about with Ground 4A, it does offer them the opportunity to regain. So another area where landlords are a little bit concerned is, well, could somebody just stay in the property forever? Well, actually, yes, if they're a working professional, but if they're paying their rent and every month, you probably want them to stay in there forever. But you can recover your property if you want to sell it or for other reasons. So there is certain circumstances around that. But so as I say, I don't necessarily think it will be the big exodus that some people are predicting. I just think there will be a slight changing of the market.
Yeah, that's great. And Graham?
Yeah, I think, again, got 2 great comments, and building on those, I think, inevitably I think there's going to be a little bit of a price war between what you've got as a PBSA type offering, which is obviously, a fixed term tenancy, and you can't, as a tenant, jump out of that easily. And obviously there's a current price differential between PBSAs and HMOs, but the flexibility of an HMO tenancy to a tenant, right, can be more attractive. And if the rent balance is set right, then I think you're going to start to see quite a split in terms of the rental offerings in different markets, depending upon location, of course.
Oh, that's great. We've still got lots of questions coming in, which is good. I think I'm going to go to Sammy's question first around, we use joint liability tenancies for student groups, such as a group of 5 friends on a single agreement. If one member decides to leave, but the other 4 stay, can I still pursue the remaining 4 tenants for their share of the rent as I currently do?
Yes, is the answer to that. So this is one thing that landlords and agents are going to have to consider, is whether or not there's pros and cons to signing everyone up on one group tenancy or having, say, 5 individual tenancies on room lets. And there isn't necessarily a right or wrong answer to this. I think it's really about your approach to risk. So let's say you have 5 people signed up on a joint tenancy. One of them wants to leave. They're entitled to do that, but the other 4 want to stay. They're going to have to find the difference in rent between them, which they may not be willing to do. If they can't do that, then they might all leave, in which case you suddenly have no people living in the property. So it's very much all or nothing. If you have 5 people on room lets, 1 people might leave. You might have a void period for that room, but you still have 4 people there, and they can carry on living there quite happily until the time when they want to leave too. So it's almost like putting all your eggs in one basket. And I don't want to say that as to say that that's necessarily a bad thing. Maybe it's a good reason to have all your eggs in one basket. But I think that there might be circumstances where you might be kicking yourself because you say, if I'd have just done room lets, I wouldn't be so exposed, or vice versa. If I'd only got them all on one tenancy, I wouldn't be so exposed. You don't have a crystal ball. There will be scenarios where you think, I could have done this better, but like I said, I think it really comes down to risk, and I think it might be sensible to do room lets, just so you're not completely exposed to a complete vacation of the property. But similarly, in that scenario Sammy's laid out, the 4 students might band together, find a friend who's looking for accommodation. They can move in, and then you've got everyone paying the rent, and everyone's quite happy. So it's going to have to be one of those things where you suck it and see, and you might have to live with some consequences, I'm afraid.
There's a question come through that's connected to that about the fire risk assessments for communal areas with single room lets. Ryan, I don't know if you know the answer to that, or if you can build on what you just spoke about.
Well, I think that question is linked to HMO management regulations, and I wouldn't have thought it'd be any different for room lets as opposed to on a joint tenancy, because the HMO regulations really come down to number of people in a property, number of households in a property. So we're just talking about how you bind those tenants into a tenancy. I don't think the method of binding them affects whether or not the property is considered an HMO, and therefore whether or not whether it affects the fire risk assessment requirement.
And I guess, Dan or anyone, is there an attraction for certain tenants around whether it is a single let or whether it is a group let? Is there different attractions to those different leases?
Honestly, for us, we do both. So we have some houses in group tenancies, but the vast majority single let. For us, it works, and we love doing single lets. There's a lot more flexibility. We often find that there's, we might have 4 people in a 5-bed house, and one of them makes a friend, so brings them along. So it kind of, having that flexibility allows people to naturally sort of join groups, and then what we find is that they then renew for a year and do a group tenancy. So we sort of see it as a way of bringing people together, and then eventually, and then some, quite often they will take the next 2 years as a group tenancy in the same house. So I think it's a good sort of community thing. A lot of students are coming to university not knowing anyone, and our model sort of makes it so that people can come together, find groups, and then sort of, throughout the rest of their university life, they're sort of with people they want to be with. So it's good in that sense, but also the flexibility, like you say, of mitigating risk. So you're not risking a whole house moving out all at once. One room moving out, yes, you lose a bit of rent, but you're still bringing in rent from the other 4 or 5 people in the house.
And we see the same pattern, Dan, really, in terms of guarantees and how they migrate from one type of property to another, and the basis of those. So, yeah, I think it is those friendships that form, obviously, during university days, and then how do you break out into more individual premises?
I think one of the big uncertainties that we're hearing about, and we've had a question come through, is about what happens at the end of tenancies. So, for example, the question that's come through is, if we agreeing tenancies next year for August 2025, where do we stand if students don't leave at the end of their tenancy? You know, and there's a few questions that we had previous to this that kind of were around that topic.
If you need to take a legal route, I mentioned before that there is a notice you can give on these renters' rights tenancies where you're notifying the tenant at the start of a tenancy that you might serve notice on them to recover possession on this ground. And the ground is basically to say you're going to give 4 months notice, it's going to expire in the summer, and then the tenants need to leave on that date. And I think particularly on this first round of tenancies where students if I give them as much respect as they're due, will not necessarily be following this as closely as everyone who is on this kind of webinar, right? We're in a bubble, and we have to understand that we are dealing with people who are not going to be as well informed as we are. So they won't know necessarily that the contract will just run forever unless they leave. So in that sense, you need to be serving these notices to give them a defined end date, and if they have a defined end date, they usually leave. I mean, currently we have a student market where if you give them, say, a Section 21 notice to leave in the summer, then they'll probably leave. But I will say a lot of the time that simply doesn't happen. A lot of students do just leave. So in that sense, I don't see it drastically changing. I think students will want to leave in the summer anyway. But I think a landlord would be foolish to not be serving those 4-month notices, to at least remind them that as an expectation they should be leaving. If you give them that reminder, I expect most of the time they'll be leaving.
Thank you. Graham, I'm going to direct a question to you because I know it's something that we've been discussing quite a bit anyway, which is about quarterly payments. So the question from Sammy is, the majority of our students prefer to pay rent in line with student finance, with loans. Is it still acceptable for us to include quarterly payment dates in agreements? For example, a student would pay rent in September in advance to cover the period until January.
So if you're, from what I understand, and I depend very much on Ryan for things like this too, is that if you're a PBSA, you can continue to vary those payment terms on pretty much whatever basis that you want, because you're not going to be subject to renters' rights. But if you are a BTR or an HMO, right, then you cannot do that. You can only take, as I said up front, you know, that news for me this week was quite interesting, that everyone's been saying, oh yeah, I can go to termly in those other types of tenancies, but that's deemed as illegal now. You can only receive monthly rental payments. Any other form of payment is illegal. So HMOs and BTRs are going to get very challenged in that regard if they try and do it.
And I guess that's the additional admin that Dan was talking about earlier as well. You know, if you're not used to collecting rent monthly, then that's going to be a significant change.
Yeah, and as Dan quite rightly points out, you know, there's more risk associated with that. I mean, you know, it's always nice as a company to get advance payments and have the cash flow, but essentially it's a risk mitigation mechanism. So, you know, we're incredibly busy talking to a number of organisations about how they're going to mitigate that risk through further use or extending guarantees.
Ryan, you had your hand up. Did you want to come in?
No, I had a point, but Graham covered it.
Perfect. Teamwork.
Wow.
James.
James.
Just to add to what Graham's saying, yeah, I mean, we work with a lot of universities ourselves in partnership, and of course universities have you know, financial advisors. They've got teams that will help students, you know, because, you know, students going to university the first time, it's the first time they're having to manage their own finances, and it can be difficult. You know, we've all been there, done that, and we still find it difficult sometimes. So I think there will be, you know, and that's where student unions will want to know more about the Act as well. When it becomes an Act, I think there'll be lots of people out there advising and helping students, manage those new payment structures that come in. And of course, as accommodation providers, I know you guys as well will work very closely with the students on that as well.
Just to continue a question on that, if this bill is a renters' rights bill and a tenant has a request to pay in a certain payment schedule, is there provision for that under the Act or not?
So if you're a PBSA, it's okay. They can come and say, maybe, the offer is, can I get a discount if I pay up front? Ryan will tell me that I'm wrong, but you could deem to accept that, right, and take what's under the Act called an illegal payment. The problem is not necessarily at that point, because who's going to police it is the challenge, right? It's when something goes wrong in a tenancy and the landlord wants to enforce something, right, and they've not done something according to the Act. So if you want to go and either evict somebody, or you want to take them, to some level of recovery, of rent, you have an illegal tenancy at that point, and that's the challenge. If everything goes okay, it can probably fly under a radar, but it will still be illegal.
No,
Thank
that's great.
you.
Thank you.
While you're in mid-flow, Graham, or James can take this, we've actually got a question about guarantors, which you'll be well placed to answer. Are we still going to be able to use guarantors, and will they be tied as they are at the moment, or will the guarantor be able to give notice at any time?
A really good question, Sarah. So I think there's quite a moving feast in that. So for working professionals, which we also guarantee, these are continuous tenancies, because they won't have either through Ground 4A or through PBSA mechanisms a finite point. The current thinking is, do you guarantee someone forever? Our current approach is that we will probably, because the average working professional tenancy tends to be just less than 3 years. So we will probably put a time limit on our guarantees and say it's 3 years, in terms, but they're annually renewable, just to make sure that if there's rent changes or other things, that we've got the commercials right in that. But for students, clearly they can give notice as they need, but then it's against a fixed term. That doesn't really change what we do, because most of our guarantees are for 12 months of duration. So all we would do is depend upon the Ground 4A or the PBSA mechanism to conclude. If someone doesn't leave, and building on the question from Deenie earlier, if someone doesn't leave where they're a guarantor client, then it's a normal eviction process if a Ground 4A has been served.
Thank you.
So just to add to that, I think I think there'll probably be more use, because people want to de-risk their portfolio more in terms of guarantors. I think we're, as Graham said earlier on, we're putting some additional things in place around our product offering to support the market, both the tenants and the accommodation partners. So and we're revealing all. So really good question. But we'll be still here to support you all.
That's great. What would you say are the top 3 risks resulting from this bill for accommodation providers, and what are the best ways to kind of mitigate those risks? Dan, I'm going to come to you first, I think.
Yeah, I mean, I think one of the biggest risks for the market as a whole is maybe not the year ahead, but sort of, in 2 years down the line, that rents will start to creep up for students, just because landlords will be trying to cover the risk. If you're getting slightly more rent, but the tenant moves out after 10 months, 11 months, then you've sort of mitigated that risk. So you might see a bit of that. I think the uncertainty is the biggest risk. So just not knowing, you could have, say you're a landlord that's got 4 or 5 houses, you could potentially see 3 or 4 of them move out after 3 months in the house for whatever reason. It's like, that's a big risk, especially if you've got sort of your mortgage being paid with the rent and things like that. Yeah, I mean, ultimately it's risk. I think that's the biggest risk. It's the risk of not knowing. I think if you're not sort of in a position where you've got ways of adapting quickly or pivoting, there are also maybe a scenario where January, February comes and loads of people move out of your houses, or several people move out of your houses, and there's just not enough students around to fill them, or no one looking. I think that's the biggest problem that landlords will face.
Yeah, and Dan, I agree. I think, you know, if I put that in slightly different context, I think the first one is non-payment risk. You know, that you know, you're not able to take upfront payments in many instances as that buffer, so you've got to find other mechanisms to cover that off. I think the second is void. You know, so how do you avoid the void? You know, in terms of how long is that? And yeah, because arguably in a void period, you've got 2 months of notice, plus, you know, then you've got to jump into saying, okay, how am I going to fill that space? And what's the easiest mechanism to doing that? And then really the third is, as you say, generally non-compliance. That, you know, if you're trying to do anything with your tenancy as an asset, and how do you tell your investors, you know, that you're compliant or not compliant? You know, so I think trying to, and what we've seen is a number of options that people have thrown out there, which are trying to, what I call, structure around the Act. And that's why you're seeing the committee continuing to upgrade what's in the Act, you know, because they're listening to what's going on and saying, no, that's not the intent. You know, this is a Renters' Rights Act, and they're going to drive it forward.
Ryan, what are your key points?
I think it will just be like I said earlier, just for this first year, making sure that if you are governed by the Renters' Rights Act, so this is not non-PBSA, that you are serving the pre-notices and the ground 4A notices when you're able to make sure that your tenants are notified of the requirement to leave. And I think you'll find if they do that, they probably will leave. Ultimately very entitled to stay, and if you get to, for example, June and your notice expires and the tenant says sorry, that they're not leaving, well, unfortunately you're going to have to evict that person, and that process is not going to be concluded before the next set of tenants are due to move in. That there are going to be situations there, but that situation already exists. If you have a tenant who is due to vacate, you know, the fixed term ends in June, let's say, and you've even gone to the trouble of serving a Section 21 notice, which a lot of student landlords don't do every single year, if that tenant doesn't leave, they can already stay on for until they're evicted from the property. That can already happen. So I think it's just going to be about easing the transition and just showing everybody that actually the sky isn't falling in. Whilst there might be extra things for us to do, we can meet that need quite easily. You just have to make sure your processes are tight, and there's going to be certain key dates circled in your calendar to say, okay, let's send out our pre-notices on this date. Let's make sure all of our Section 8 notices go out on this date. Make sure everything is done that can make the transition as smooth as possible. If you're not doing that, I think you're taking a major risk. But I think if you are doing it, you're doing everything you can to make sure it goes well.
I think as we come back time and time again, that there's going to be a lot more admin involved with this process that people really need to be mindful of and make time for that and resource for that, which I think is something that's really important. Anyone else on kind of risks and mitigation? No, I think we've covered off most things there. I guess one thing is around kind of what identification a student needs to present to note that they are a registered student, and at that stage and not have to wait till August to actually prove they're a student. So there's kind of a no risk for PBSAs, and so what is the requirement, I guess, from landlords around determining who's a student and who's not a student?
Yeah, so this sort of, I guess there's a number of different mechanisms, and this is moving as well, so that probably doesn't help. It's not part of renters' rights, but you know, landlords' responsibilities on ID are quite stringent, and there are, again, penalties for not complying. So generally speaking, if you're a UK or Irish citizen, you have an indefinite leave to remain, and you can just show your passport at any point in the process. The challenge obviously comes with internationals, and when internationals do it. So you can't have what they call a right to rent check. You can't do that more than 28 days before you enter into a tenancy agreement. So, that's a timely activity. Now, you can ID them before that. So there's a difference between IDing and right to rent. Right to rent is typically now a government-driven process. They have quite a useful website where you can use a share code, which is the government's approval for you to be here, and you give that to your landlord, and they just validate that way. You can also delegate that to other third parties to do that for you, which gives what they call, I think it's called a statutory excuse, that you delegate that authority to someone else so you don't get fined for not doing it. And it's useful to use third parties to do that because, they will retain that ID and documentation for you. You have to retain it 6 months after the tenancy finishes. And again, just Deenie, more admin if you're not careful in complying with that.
Yeah, and just to add to that, one of the things we've done over the last few years, and I know a lot of other businesses have done as well, is introduced KYC, which is Know Your Customer. So it's you will have all done the ID when you've opened up a bank account, the NHS app, where you upload your biometric ID, driving license, passport, and then you do sort of a spin your head around video, so it matches you. So there's a lot of that intuitive stuff around now, which we take on. Also, a lot of students, we deal with a lot of international students. 70% of our business is international students, and we they have different forms of proof that of study, so offer letters, things like that, which do come well in advance in a lot of cases of them accessing their rental services, and of course student visas, etc., etc. So there's quite a few bits and pieces around that for sure.
Okay, that's great. Thank you. I'm conscious that we are coming towards the end of our session, which has been brilliant. We do appreciate all the questions. If we can't answer them all, we will certainly try and answer them kind of through social networks over the next few weeks. I guess in terms of kind of making sure that we're as prepared as possible, what would you say is your top practical tips that people should be doing in the next 4 weeks to make sure that they're prepared, they're able to deal with these changes coming forward, and get ourselves in as good a position as any, knowing that after the new year, this is when things are going to happen, and it's going to be quite quick, as you say, 3 months, Ryan, until it's going to be implemented. So what should people be doing over the next month or so?
Just on the basis that we know what the bill's likely to look like, I think the best things you can possibly do is just make sure your paperwork is as up to date as it can possibly be. So, for example, if you're PBSA and you are going to be operating on a non-housing act agreement, those agreements already exist. So you can get those agreements, you can get them drafted up, so you could be ready to go. If you are going to be governed by the Renters' Rights Bill, so you're going to be it's going to be a assured tenancy. I mean, I have a Renters' Rights Bill compliant tenancy agreement for sale. If I can give that little plug. But you've also got, I would also again stress if you wanted to produce perhaps some template letters. So like I said, there's a pre-notice requirement for ground 4A. You can write that right now. You basically say that we are a landlord. We intend to relet the property to students in the next academic year. We're putting you on notice that we might serve you with a ground 4A notice later on in this year to bring the tenancy to an end. You can write these things now, because I don't think that mechanism is likely to change at all. So do what you can now. We don't know everything 100% black and white yet, but we know most of it. So just take the steps that you can take until it's all finalised.
Thank you, Ryan. I know, Dan, you've already done quite a lot of these things. Is there anything that you would advise other people in your position to kind of get cracking with now?
I think one of the things we are going to be looking at is kind of looking at what the worst case is. So what is the worst case? So everyone moves in the summer and we have X amount of people moving out. What can we do to mitigate that? What can we put in place now to make that process easier? What options can we give students, and how can we improve our offering? So I think that's the biggest thing we're going to be working on. But like Ryan said, the paperwork aspect is big. You can get going on a lot of processes. I think what we're starting to do is get processes. So in this circumstance, if X amount of people move out, what's the process and what do we need to do? But also the process of communication with tenants, so making sure they're informed, sort of going into everything. I think that's the main thing you can do, is just get prepared with almost sitting and thinking about what might happen. I think we know from this year, last year, all years, there's always people that move in and want to move out pretty quick. So it's just thinking about the things that are already happening and already problems and what that's going to do to the market and your business. But also, I think one of the big things that we're sort of focusing on is making sure that, like I said, the offering we've got is something where students are supported. They have an open communication channel with us. So yeah, that way we eliminate risk.
That's it. Thank you. James, your top tips?
Yeah, follow on from what everybody's saying. I think if you've got different types of property offerings in your portfolio, so we're talking to some of our PBSA partners, for example, that also have HMO assets. They also have BTR. So even though the PBSA side of things will be exempt with the common law tenancy, the BTR and the HMO sides of their portfolio, which they may have acquired or built themselves, they need to come under renters' rights. So we're actually discussing with them different offerings, what we can do, but also giving them advice on from what we know, how to best approach it and de-risk those particular sides to their business. So that's a really important thing. But yeah, just I agree with everything that's been said so far.
Graham, have you got anything to add?
Probably 2 or 1.5 things, actually. I think it's really easy to forget in all of this that the real test of it is rent. Where you set your rents. Totally agree with Daniel that there's a lot of things that you can do surrounding that to make it a more robust, sustainable offer going forward. But people will judge us by rent values, to start with. And I think that's going to be a very interesting play between PBSAs and BTRs moving forward, about where they're positioned and what level of occupancy you're going to attract in that. So occupancy rates are going to be the real test of this against that rent offering. We're going to be busy refining our void offer. That is getting quite a lot of questions on it at the moment. So James certainly and the business development team are incredibly busy around that right now.
Perfect. Thank you. And we have come to the end. So thank you to our panel of experts, and thank you to everybody who has joined us today and for being such an engaged audience with the questions. We're conscious that we haven't been able to get round to answering all of them. But if you all make sure that you follow the LinkedIn page for Housing Hand, we will gather the panel together again over the next week or so and over Christmas and into New Year and try and get round to some of these questions as well, because it's clearly there's still a lot of uncertainty, and if we can help to answer the questions, then we will do. So thank you all again, and hope this webinar has been useful.
Merry Christmas to everybody.
Yeah. Right.
Thanks very much.
Thanks, everyone.